But you don't see the scene like in Stowaway with Shirley Temple out there.
No, in fact, often I don't have. I think it's rarely a situation where
And
someone comes out and asks the child directly,
yeah.
"Which parent do you want to be with?"
Uh-huh.
Because that's an uncomfortable position to put a child in. I think that most evaluators are a lot more subtle about how they would explore a child's preferences. Although I think some older children, they know what's going on when they go to an evaluation, whether they've been prepped by a parent or not. I think they often know what it's about, and some children, I think, express very strong opinions about what their preferences are. And then other children who may have opinions, I think, are often unwilling to express them because they're protective of their parents. Children usually don't want to hurt either parent, and they may. The funny situation we run into all the time as attorneys is our clients will frequently tell us what their child wants, and they're very certain of it. And what they don't know is that child is perhaps telling the exact same thing to the other parent, that they want to be with the other parent. And so when the evaluation is done and the court-appointed evaluator reports back their recommendations, you find out that the child said something completely differently than what either parent expected they would be saying, and that's not uncommon at all.
Wow. Okay. Next difficult area. What are move-away cases?
Well, move-away cases are very difficult, and it's usually the situation where the parents have established a custody and visitation order, and one parent wants to move away a sufficient distance, change their residence a sufficient distance that the existing custody and visitation order doesn't work. And they can be really hard cases on everyone. I've had cases where one parent, after years of establishing a custody sharing arrangement with the other parent, wants to move all the way across the country or even outside of the country based upon, often it's a change of employment, transfer by an employer, or they've remarried and their new spouse is being transferred. Often the allegation is economic reasons, that living here in Santa Clara County is incredibly expensive. They can't afford decent housing, and they could go live back in their hometown, maybe somewhere in the Midwest or back east, where housing prices are substantially lower, and they might be able to get a job making just as much income. And then they allege that they have family support back there and friends and a history in that community, and the child would be better off. Frequently, the allegations are the school system is much better at the out-of-state location than our local schools here. And that's kind of how the dispute starts. And the decision-making process is, you'd think it might be difficult, but the law has given us some basis that in some cases makes it relatively easy for the court to make a decision. And this goes back to a case called Burgess, California Supreme Court case, and what it told us is a custodial parent, meaning a parent who already has a child custody order giving them physical custody, has a presumptive right to move. And so the other parent has a high burden then of stopping that move, or at least the child can't stop the other parent from moving. You can stop the child from moving, but you'd have to show detriment, or that there would actually be a reason to change custody if to the other parent, the non-moving parent, as if the move were not occurring. You can't use the move itself as the basis for preventing the move, saying that creates the detriment. So a parent with physical custody is probably going to prevail in that move-away request, which is one reason why you see early on people that are informed will object to a sole physical custody order to the other parent, and they'll demand joint custody, or they'll want physical custody because they're concerned of a future move away. And I think most lawyers will advise their clients to think about the future and test them on, what is the risk that either you or your soon-to-be future former spouse might be moving away. Is your spouse originally from some other state or some other country? Do they still have ties? Where is their employer headquartered? Those sorts of things to look at, are there some risk factors that this is somebody that might want to move away at some point.
Right. So it seems so romantic that you meet this person from an exotic place. You know, you're traveling in Europe and fall in love with this handsome Frenchman or whatever. You know, they put it in the movies all the time, but then they don't talk about if things don't work out, and then suddenly two people want to be in two different places, and what's that going to be, the impact on the kids?
Incredibly difficult, and people, and it isn't that unusual when people get divorced that one of the divorcing spouses give serious consideration to moving back to their home state, their home country, or maybe they're from Southern California and they want to move back there. And you're right, when people are in love and thinking about getting married, they aren't thinking, gee, 10 years from now, what if we get divorced and we have children and the other parent wants to go back to their home state or home country? It's going to be a very difficult situation.
Right. All right. So you have one of these orders and maybe conditions change or whatever. Can these orders be modified?
Yes, child custody is an order that can always be modified by the court right up until a child turns age 18. The standard, again, may be different depending on whether it's a temporary versus a final child custody order. Again, the standard would be best interest of the child or substantial change in circumstances. That if you have a temporary order, that would be an order that is not characterized as final or was not made by a judicial determination after a contested hearing. Then the standard is only best interests, and it is relatively easy to allege that it's appropriate to change the order. And you know, why would people change the order? Maybe it's not a move away of sufficient distance that it would cause it to be impossible to carry out the existing order, but maybe it means there's going to be a change in school, and that might mean a change in timing, or because of the location of a child's school, it's going to be more difficult for a parent, given their employment hours, to pick up a child from school. So it could be as simple as, I need to change things because my son's changing from junior high to high school and he gets out at 3 o'clock versus 2 o'clock, and that means we're going to have to change who picks him up after school or when the Friday weekend visit begins.
Okay. Well, believe it or not, Mark, we're about out of time here. So I guess at this point I'm just going to thank you very much for sharing this important information and some of the insights that you've gained working in this area, and I really appreciate it. I'm looking forward to having you as a guest another time on the show. So folks, think very carefully about when you're getting what you're getting into in getting married, and who you're choosing, and also when you decide to part, and get good help, seek good counsel from a good attorney. And with that, I'll say thank you very much for joining us, and I'll see you next time on Financial Insider Weekly.